Hey, it's Guy. I wanted to touch base with everybody. As you know, I am an Indiana estate planning and probate lawyer. And, there's been some issues now with this COVID-19 going on. And, we're not supposed to have we're supposed to have social distancing with people. And a lot of folks aren't coming into the office. And the Supreme Court has just put out an order yesterday that I think is important. And the title of this order is, "In the matter of the emergency procedures for the witnessing of wills related to the 2019 novel coronavirus." And so what it says, for probate and estate planning documents executed during this period of public health emergency, they usually require testing witnesses and or testators to sign these documents in the actual presence of other people. The court deems permissible substantial compliance with those provisions to include simultaneous or contemporaneous remote appearance by audio or video communication technology. So you can have the remote witnesses and remote testator compositively identify one another. So say we get on a Zoom conference and the notary's in my office and you have been to my office before, or you send us a picture of your driver's license. So the remote witness and remote testator can positively identify one another, and the parties are able to see the execution of the document. So we would send or email the document to the testator, and then they would pull it down, and you can go and take the document up to the screen and show the person what the document is. And the next part is that the document being executed specifically references the order preceding the attestation or self-proving clause. So we're actually putting forth in the document that this is pursuant to the court order, and we know that it's not, that meeting the form, that the signing is actually going to be remote, and that within an attestation or self-proving clause incorporated in the document, the message used or the methods that are used for remote appearance and for securing signatures by specifying the technology platform used. So if you're going to use FaceTime, or if you're going to use Zoom, or if you're going to use Blue Jeans, or you're going to use Google Hangouts or Google Meet, that would have to be in the document, and then you would have to describe what was done. So-and-so was there, so-and-so showed me the document, I had a copy of so-and-so's license, and that type of information would be in there. And then finally, that the document contains a statement preceding the attestation or self-proving clause, which acknowledges and confirms that the document shall be re-ratified or re-executed in compliance with the regular statutory procedures within 90 days after the health emergency expires. Now, nobody wants anybody to get sick during this COVID-19 crisis, but should somebody come down with the virus and they're concerned about, what would happen if they have to go into the hospital and have to be put on a ventilator, and who would be able to take care of their financial affairs, or who would be able to take care or make their healthcare decisions. They might want to quickly get a power of attorney, but yet if you're infected with the virus, nobody's going to want you in their office, and you can't subject a notary to it. So these options are available for folks. Hopefully nobody needs it, but these remote signing options are now available thanks to our Supreme Court lowering the restrictions on signing documents because of the health crisis. If you have any questions about Indiana estate planning or probate matter, you can always reach out to me. I am Guy DiMartino. Have yourself a great day.